Uh, okay, hi guys. Welcome to CLLST, and today's session is based on landmark judgment. So, this session would be divided in multiple episodes. So, it's like obviously we have so many months, and basically from January till October, we are already in 10th month. So, by now, the Supreme Court has decided, or there are many landmark judgment which we need to know. So, that may be important from your CLAT perspective, as you know that in CLAT GK section will be having questions based on landmark judgments, and then under ILET and SLAT and other exams, they directly ask questions in legal section from the landmark judgment, or you can say knowledge based questions. And also, when you are talking about landmark judgment, so always keep one thing in mind, that apart from remembering the case name, you also need to remember the judge's name, because sometimes they do ask question that who was heading the bench, or for that matter who decided this particular case. For example, I'll just tell you, or I'll just explain you one case in which it was very much important to know the judge's name. For example, when we talk about Sabrimala issue, so you know that this case was decided by 5 judge bench, or you can say constitution bench, and the judgment was given by 4 is to 1 ratio. That means 4 judge gave in favor that women shall be allowed to enter into temple, and Justice Indu Malhotra, she gave a dissenting opinion. That means she stated that women shall not be allowed to enter into temple. Women of menstruating age shall not be allowed to enter into temple. So why she stated like that? Because she was of this opinion that we shall not play with customs, we shall not play with tradition, and we shall agree to, or we shall follow whatever our custom and tradition states. So basically, in that case, the role of Justice Indu Malhotra was very important, because it was questioned that being a lady judge, how come she is stating that women shall not be allowed to enter into temple. So sometimes it is also important for you guys to remember the judge's name, that which judge has stated what and who was heading the bench. So that was with respect to the aspect which you need to remember. So today I have picked 6 judgment from the month of February, so I would be discussing each of them. So the first case is Kapil Agrawal versus Sanjay Sharma. Have you heard about this case? Any one of you? If you have any idea about this case. So this case is basically talking about landmark judgment. This case is basically talking about writ jurisdiction. So it the judges stated that under Article 226, which is basically where you have the right to approach the High Court, it can be invoked to quash FIR if it is found to be violation of, or you can say if it is found to be abuse of process of law. So the court stated that the jurisdiction under section 482 of CRPC or under 226 of Constitution is designed to achieve certain purpose, and that criminal proceeding ought not to be permitted to degenerate into weapon of harassment. So basically the law cannot be used as a weapon of harassment. And when we talk about writ jurisdiction, so what do you understand by writ jurisdiction? Anyone would like to say something in or you can type in the chat box. What do you understand by writ jurisdiction? I'm waiting for the response, guys. A writ is basically, you can call it as a quick remedy against injustice, or it is a kind of device which is used for the protection of rights of citizens against any encroachment by the government authority. So basically, we all know that fundamental rights are being given by the state. State is the one who is providing us the right. So in case if there's a breach or violation of fundamental right, we can always file a suit, or we can always file a writ petition in High Court and Supreme Court. Arushi is stating it's directly approaching the Supreme Court. Then Tanish is stating specific order to protect our rights. Okay, in case of violations, it is not only in case that you can approach the Supreme Court. You can also approach to High Court under writ jurisdiction, and under High Court you can approach. To High Court you can approach under Article 226, and to Supreme Court you can approach under Article 32 of the Constitution. And when we talk about writ, so it originated in Britain, where there were kings or queens prerogative writs, and were commands to the judicial tribunal or other bodies to do or not to do something. And since the writs were carried by the authority of crown, they were to be obeyed. Similarly, in case when writ is being issued by Supreme Court and High Court, you have to obey to the order of Supreme Court and High Court, and it is a speedy remedy and is made available without going into technical or technicalities, or it is basically without going into avoidable technicalities. It is an extraordinary remedy which can be expected in certain circumstances. And when we talk about writ, so there are five kind of writ. One is habeas corpus, writ of habeas corpus, which basically means to demand to produce a body. So basically, where a person has been detained without any reasoning, so there the court may issue writ of habeas corpus asking the concerned authority to state why you have arrested that particular person, and if there is no reasoning given, then the person has to be released. So that is under the case of writ of habeas corpus. Then the second one is writ of mandamus. That is basically means to command. That means if one of the any of the authority is not performing their duty, you may ask the court to issue writ of mandamus. And mandamus is basically where the court is authorizing or asking the authority to do certain work. For example, if municipality in your area is not doing certain job, so there you can file a writ of mandamus, and the court will ask the municipality to do that work. So that is basically writ of mandamus. Then you have writ of certiorari, which basically means to inform. So it was essentially a royal demand for information. It can be issued against constitutional bodies. It may be defined as a judicial order operating in personam and made in the original judicial proceeding or legal proceeding, directed to any body, constitutional body, or non-statutory body, or person requiring the record of any action to be certified by the court. So that is basically writ of certiorari. Then prohibition is another order, which is basically a judicial order to the agencies, which may be constitutional agencies, which may be statutory agencies, which may be non-statutory agency, from continuing their proceeding in excess or abuse of their jurisdiction or in violation of principle of natural justice. So basically, you are prohibiting that particular authority to do certain things. So it is issued to protect the individual from arbitrary administrative action, you can call it. Then the next one is quo warranto, so which basically means by what authority you are holding certain post. So this can be understood through certain examples. For example, I mean, let's assume that it's an hypothetical situation where our prime minister, he won the election from Banaras. So let's consider that when he was fighting election from Banaras, he did not win from there, and he was made prime minister of India. And when a person is not, has not won election from a particular constituency and is holding certain post, so within 6 months he has to come from, or win an election from any one of the constituency. And if he fails in doing so, after 6 months he has to resign. So suppose in this hypothetical situation where our prime minister, he lost the election in Banaras, and he was holding the post of prime minister, and after 6 months also he couldn't win, or he couldn't win from any of the constituencies. So there the questions or writ of quo warranto may have been issued against him, asking by what authority you are holding this post. So that is basically writ of quo warranto, where it is like it is being sought to clarify in public interest the legal position in regard to claim of a person to hold a public office. Also, when we talk about Article 32 and Article 226, you always have to keep in mind that Article 32, when you compare Article 32 and Article 226, so under 226 you can approach High Court, under Article 32 you can approach Supreme Court. But which article is having wider power, Article 32 or Article 226? Anyone? Which article is having wider power, Article 32 or Article 226? It is Article 226 which is having wider power. That means under Article 226, High Court can decide the matter related to your violation of fundamental right. And then High Court can also decide matter related to violation of your legal right. But under Article 32, Supreme Court will decide only the matter which is related to your violation of fundamental rights. So here you can say that High Court is having wider power under Article 226 than Supreme Court. Also, when you talk about Article 226 and Article 32, so you can directly approach High Court or you can directly approach to the Supreme Court. Now the question is which court you shall go first, whether you shall go to Supreme Court or whether you shall go to High Court. So there's no bar in approaching Supreme Court or there's no bar in approaching High Court first. But when you approach Supreme Court, so Supreme Court at various instances had stated that it is advisable for you guys to approach first High Court and then come to me, because you have a remedy which is available or which you can get at High Court itself. So why to waste time and why to come to me? Although you can come to me directly also, but I would advise you to first get the remedy from High Court, and if you're not satisfied by the High Court, then you can come to me. So this is what was decided in under Kapil Agrawal versus Sanjay Sharma, that under Article 226 also FIR can be quashed. Then the second case is Kanis Fatima versus Commissioner of Police. So this is again with respect to right to protest. So we know that right to protest is a fundamental right guaranteed under Article 19 of the Constitution. And during CAA protest or during farmer protest, this has been in question very much, like that whether a person is having right to protest or not, or if a person is having right to protest, to what extent they can protest, and is it like that they can protest wherever they want to. So this has been questioned multiple times, and in fact, during this farmers' protest, which is currently going on, where they block certain roads and all, this is something which is again in question. So here the court had stated that you have right to protest, but it doesn't mean that you can protest anytime and anywhere. Wherever you want to protest, you cannot do so. So the Supreme Court had dismissed the petition against the Shaheen Bagh judgment. So there was a petition asking the Supreme Court to review Shaheen Bagh judgment. So Supreme Court dismissed it, and Supreme Court stated that the demonstration expressing dissent have to be at designated place. That means if you want to protest against the government, you can go to a designated place and you can protest there. If you are going for spontaneous protest, maybe like today or tonight you guys decided that we are going to protest against something, so the spontaneous protest can be at any place, but where you are carrying a prolonged protest, for example CAA protest which was happening at Shaheen Bagh, or for that matter when we talk about farmers protest which is still continuing. So wherever you are carrying a prolonged protest, it has to have at a specific place, and there cannot be continued occupation of public places which is affecting the rights of others. For example, when you talk about farmers protest which is going on, so it does affect the right of people who are commuting from that area, or for that matter when during CAA protest when we were going to our head office, so there this Shaheen Bagh entire area was blocked, so it was very much difficult for us to commute on daily basis. So you have a right, but then you also have a corresponding duty. You cannot just claim that I have been given fundamental right. You owe a duty towards society as well, and that means that you can't violate the right of other members of society. So this was something which was decided in Kanish Fatma's case. Then the third one is Vikas Kumar versus UPSC. So in this case is with respect to disability of a person. So this was a 3-judge bench. Justice Chandrachud was there, Justice Indira Banerjee was there, and Sanjeev Khanna was there. So they observed that the decision in B. Surendra Mohan versus Tamil Nadu would not be a binding precedent. So you know what precedent is. If a court decides something, and which is a very, you can say it can act as a precedent. For example, Keshwanand Bharati judgment, it acts as a precedent. That means it is binding on everyone, and it defines what is basic structure. So basic structure has to be taken into consideration. So here the court stated that after the coming into force of right of person with Disabilities Act 2016, the bench held that the facility of script can be provided for person with disabilities other than those having benchmark disabilities. So it is basically talking about the disabilities and whether the person have a right to get the script or not, or whether the person can be denied on the ground of just disability the access to something or not. So this was decided in Vikas Kumar versus UPSC. Then the next case is Neelam Manmohan Atavar versus Manmohan Atavar. So in this case, again, a division bench comprising of Justice Chandrachud and M.R. Shah, they decided or they stated that litigant cannot seek rescual of a judge from hearing case on ground that he or she may not get a favorable order. So basically, you can't say that this judge or this bench is not going to give me a favorable judgment, so I need another bench. That cannot be a ground for getting this order. So a litigant cannot be permitted to go beat the court by seeking a bench of its choice. You cannot seek a bench of your choice just because you feel that this bench is not going to give a judgment in my name, or this bench is not going to favor me. So on that ground, the court is not going to decide or the court is not going to change the bench. So this was Neelam Manmohan Atavar. Then the next case is State of Gujarat versus Balchandra Lakshmi Shankaran Dev or Dave, however you pronounce it. So it is basically where the court had stated, or court, talked about corruption. So court stated that corruption is an offense against society, and at multiple instances, this is something which has been discussed, that corruption is a kind of weed which is affecting the society, or it is against the society. And Supreme Court also set aside Gujarat High Court's judgment where he had acquitted the accused. So Supreme Court stated that if somebody is, liable for, or somebody is accused of corruption, you can't acquit that person. That person needs or deserves certain sort of punishment. Then there's another case also, guys, which you may go and you may search for, where the Supreme Court has stated just discovery of money from a public servant does not amount or does not state that that person was involved in corruption. Exactly, I mean, this is again the judgment of February, so you may search, but I thought that's not important from the exam perspective, so I haven't included it. But yeah, when the court has stated that corruption is a source of, or you can say is an offense against the society at large, so that is an important statement. So that was decided in State of Gujarat versus Balchandra Lakshmi Shankar Dev or Dave. And the last one for today is Union of India versus K. Nazir. So in this case, the court talked about the speedy trial. So you all know that speedy trial is a kind of fundamental right. And the court stated that the violation of fundamental right to speedy trial is a ground for constitutional court to grant bail in UAPA case. So if a person is not getting speedy trial, or you have locked the person without giving them the trial opportunity, just on that ground you can't put a person in jail. So that is basically which was decided here, that right to speedy trial is a ground for constitutional court to grant bail in UAPA case. So this was all about today's cases or today's session. Basically, I have decided that I'll just pick 5 or 6 cases so that you guys remember. And every week I would be covering 5 and 6 cases so that it's not difficult for you to remember, or it's also not difficult for you to forget the cases. So this was all about today's session, guys. Thank you. I hope I was of some help. Thank you.